A very good morning to everyone. A very good morning to everyone. If you can hear me, please write yes or hello. Hello. Am I audible, everyone? Good morning. Good morning. My name is Shishir Shrivastava, and I'm the advocate who is practicing in the High Court of Chhattisgarh as well as in the District and Session Court of Raipur. As well as I'm also associated as a legal trainer with the Rostrum Legal. And today I'm going to share some insights into the preparation for the Judicial Services examination, for which every one of us has assembled here. And we all know that this is a coveted post in the sense that, yes, we all have a student who enters into the profession of law always has a desire, sometimes or the other, that he should also be seated on the seat of the judge. And there are lots of privileges of being a judge. Apart from deciding the civil and criminal cases, you have the power to decide upon the questions of law, which very few gets the opportunity. It's a different fact altogether to say that this post is for the subordinate courts. But yes, once you enter into the service, the promotions are really going to happen, and you are going to reach to the top. But it is very difficult to reach to this particular position, especially when it is an exam for the seats like judicial magistrate first class or the higher judicial services. So the examination is extremely tough, and we need to know as to what is the good strategy which can give me a sure shot result in one attempt, in the first attempt itself. Many of you might be the students of the college, final year or fourth year students of the law colleges. Those who are doing 3 years law courses must be pursuing their courses as of now. Some of you might be the previous attemptees who must have attempted the previous examinations but but would not have been able to succeed. So let's try to find out in this particular session, let's try to find out as to what could be the possible reasons as to why we do not succeed, or those who are going to attempt the examination for the very first time. Let's try to find out what it takes to prepare for the judicial service examination. So let's get started with it. See, we all know that the examination is a three-stage examination. The first stage is the preliminary examination, the second stage is the mains examination, and the third one is the interview. In some states, the interview or the marks which has been allotted to the interview are very nominal. Like, first, say, for example, in case of the state of Chhattisgarh, the interview contains only 15 marks. But if you see the states like Uttar Pradesh, Bihar, West Bengal, they have a fairly good amount of marks which have been allotted for the purpose of interview. Why I have started with the interview stage? See, the interview stage is the ultimate stage where you're going to reach, and where you are going to get selected into the merit list. When we start the preparation for the preliminary examination, we need to keep this in focus that our ultimate objective is not just to clear the preliminary examination. And this brings us to a question as to what is the nature of the preliminary examination. Preliminary examinations basically are the screening out test. Screening out test means that the non-serious candidates are filtered out, and therefore they contains the objective type questions. These objective type questions are of different nature, which I'm going to discuss. So the first stage is to clear the preliminary examination. the High Court, if the High Court is the examination conducting authority, or the Public Service Commission, State Public Service Commission, in case if the State Public Service Commission is the examination conducting authority, notifies the number of posts for the civil judge recruitments or the judicial magistrate first class recruitments every year. When these posts are notified, you need to see as to how many number of posts are there. Now, say for example, if the number of posts which have been notified are 41, how many students will get selected into the mains examination? It will be 41 into 10. It is 1:10 ratio in which the students get selected for the for writing the mains examination. Once you reach the mains examination stage, 41 into 3, that is 1:3. 3 candidates for one seat will be called in for the purpose of interview. So you can ultimately analyze as to how tough the competition is, and every single mark counts. Every single mark counts. Even if you have been able to score the same amount of mark as that of in the as that is of the cutoff, even then there are chances that you might not get selected because of a point mark difference. So we need to be very, very robust in preparation. We need to have a very thorough preparation. So the first step is to take the preliminary examination seriously. Now, what mistake many people do is that many people think that if I will be able to look into the previous 10 years papers and if I am able to solve the previous 10 years papers, I will be able to clear the preliminary examination. Well and good. Yes, you will be able to clear the preliminary examination. Even I say that you will be able to clear the preliminary examination. But what next? What next? You have to ultimately write the mains examination, which requires a thorough conceptual knowledge of each and every subject. And in case of those states where the general studies papers is also conducted, you must be also reading about the general studies. That is both the static and current GK. So what should we do? So your preparation ultimately should start from your preliminary stage itself. What you have to basically do is you do your preparation for the preliminary examination so thoroughly after reading all the concepts, after reading all the sections. What are the concepts included there? What are the doctrines included in the incorporated into the sections? What are the the case laws, the recent case laws? What are the landmark case laws with regard to those particular concepts? We need to keep these all these factors into mind, right? So let's discuss as to how first we have to study for the preliminary examination. The very first mantra is that when you start your preparation for a preliminary examination, you must take a year-long approach. If you start your preparation for the preliminary examination, you must prepare for the examination in such a way as if you are going to write the mains examination and you are going to appear for the interview. Because ultimately what happens is, in case if you are able to secure the seats in the mains examination after clearing the preliminary examination, you are only going to get 40 days from the date when the results of the preliminary examinations are declared. You are only going to get 40 days for preparing for the mains examination. There will be a gap of 40 days from the date when the results are declared, and this is universal for almost all the states in India. You're only going to get 40 days. So once you clear the preliminary examination, those 40 days, and I'm telling you very practically and out of my own experience, once you get selected, those 40 days is not sufficient enough to prepare subjectively each and every subject. Apart, in addition to your general studies, it is not at all possible. So when you are preparing for the preliminary examination, prepare it in such a manner as if you are going to write the mains examination and you are going to appear for the interview. So that what happens is, when the results are declared for the preliminary examination, you are automatically, you automatically knew that you are going to get selected. Now you are going to revise those subjects. Now you are going to do the revision of all those subjects which you have studied earlier in your those 40 days time limit. And ultimately, when you are going to do a revision in those 40 days, it is most probable that you will be able to clear the mains examination as well. And now you have to prepare for the interview. An interview is going to be a easier task for you because it is more of a personality test rather than the knowledge test, because the Public Service Commission or the High Court, whatever it is, has already tested your knowledge in your preliminary and mains examination. So they are going to test your personality. It may be also a kind of a viva voce where the panel sitting there might be asking you some questions related to the subject matter. It may also happen that they may not be asking you the questions related to the subject matter. So it is more of a personality test. They will be looking into you, the aspect as to how much you are able to withhold the pressure, how much you are able to take the stress, how you handle the stressful situation. That is all a personality aspect. When we are reading for the preliminary examination, yes, the very first important tip is that please survey before starting any subject. Before starting any subject, please survey the question papers of last 10 years. You must do the survey of the question papers of last 10 years and see as to how the subjects have been dealt. Now, say for example, if you're looking into the question paper, please see as to how the questions from different sections have been asked. If it is, say for example, culpable homicide amounting to murder and culpable homicide not amounting to murder, that is, for example, say section number 299 and 300 of the Indian Penal Code, how the questions have been asked. Now, when we discuss the kind of questions, I will categorize questions into three categories. The first is the question which is conceptual in nature. First is a question which is conceptual in nature. How it is conceptual in nature? Now, say for example, I've given the example here. If the question comes, what does estoppel means? Now, we all know that the concept of estoppel is given in section 115 of the Indian Evidence Act. And in one or the other form, it has also been included in section number 41 and 43 of the Transfer of Property Act. Section 43 is also known as the doctrine of feeding the grant by estoppel. Right? So these are conceptual questions. Now, if you say that the estoppel means to stop a person, you will not be able to, it will not be easily comprehensible by you. You will not be able to easily believe in this fact that there cannot be a simple answer to this particular question. But the answer is, it means to stop a person. Now, what happens is when we read section 115, we find out that the estoppel means stopping a person from claiming the rights over the property or going back on his words. This is exactly what is a concept of estoppel given in section 115 of the Evidence Act. But what does estoppel basically means? To stop a person. I'm stopping you from doing something. Now, whether it is stopping you from claiming anything or whether it is stopping you from going back on your words is a different fact altogether. But I'm stopping you. Now, we go for the answers which are more related to the section number, but the question is conceptual in nature. And this is how we lose 1 mark. And if there is a negative marking, you're also going to attract the negative marking. Right? So first, analyze the previous 10 years papers and try to find out as to how the subjects has been dealt with. What kind of questions has been asked from that particular subject? If it is Evidence Act, whether the questions are conceptual in nature, or let me change the slide now. Whether the questions are direct questions. How the direct questions? Now, say for example, I've given the example here. What is section 34 of the Indian Penal Code? Yes, it is common intentions. So we have identified two kinds of questions. One, the questions which are conceptual in nature. Two, the direct questions which may ask you what does this particular section contains or what does this particular doctrine actually means. So these are the two different kinds of questions. One is conceptual in nature and the other one is a direct question. So so in this way you can identify the questions for each and every subject in these forms. Slides are not visible. Let me increase the font size. Is it okay? Is it okay, Shreya? Is it okay now? Yeah, okay. So we have identified two kinds of questions which are asked in the preliminary examination. One are the direct questions, and the other one could be your questions based on direct questions based on section number. Right? So you have to identify. Then the third survey which you are going to do for your examination is the questions based on case laws. Now everybody of us knows that we are the law students. We are the law students. And we cannot complete our studies unless we have not studied the case laws. For reading the case laws, it's like the ocean. A study of the case laws is like the ocean. Just like we read the news daily in the newspaper, and it keep on coming and new news used to keep on coming daily. So we have a lots and lots of things to study. So is the case with case laws. So the first thing which we have to do for reading the case laws or for studying the case law from examination point of view is that we have to identify the leading cases. Now you will ask, what are leading cases? So leading cases are the cases which change the course of history or which changes the course of jurisprudence. Say for example, Menka Gandhi versus Union of India. If you see the situation before 1978 when the Menka Gandhi ruling was delivered by the Supreme Court, the concept of just, fair and reasonable procedure was not read into the due procedure established by law in Article 21. It is only the after effect of Menka Gandhi that the concept of just, fair, and reasonable procedure has been brought in. Now, the procedure established by law in Article 21 is read as just, fair, and reasonable procedure. So it's a leading case. Similarly, in 2018, we have witnessed a very leading case in the form of the case Puttaswamy versus Union of India. What does this case contains? This case basically states that right to privacy is now a fundamental right under Article 21. Why is this a leading case? Because earlier, before the delivery of the judgment of K.S. Puttaswamy, right to privacy was not the fundamental right. It was not at all the fundamental right. Right? So this is a leading case. So we have to identify what are the leading cases, whether it is your constitutional law, whether it is your Indian Penal Code, whether it is your Evidence Act, CRPC, whatever it is, you have to identify the leading cases. Then there must be some questions also based on the cases which are not leading cases. How to prepare for those questions? So the very easy strategy for that is, please go to previous question papers and try to question papers of almost all the states and try to identify the common questions and the common case laws which have been asked in those examinations and try to find out the common answers. Now, say for example, if X versus Y is one of the case law, which is not so leading case, which is not such a leading case. But yes, it has been asked in the state of Uttar Pradesh as well. It has been asked in the state of Bihar as well. It has been asked in the state of Andhra Pradesh as well. With the common answer that yes, X versus Y is the answer for this particular question. This is how, after surveying the previous papers, you will be able to identify that yes, this is though not a leading case, but has been asked in most of the exams. So I must keep this case law into mind. If you follow these three strategies, if you follow these three steps, if you survey the previous question papers and try to identify the questions, whether they are conceptual questions or questions, or whether they are direct questions or whether they are questions based on case law, you will be able to ascertain the fact that the situation how you have to study the subject. Now, say for example, if you have surveyed the previous question papers and you want to start with the Indian Penal Code. Now, when you are going through the contents of 299 and 300, whether going only through the Bare Act is sufficient. Though I must, be very clear here that your preparation should always start from the Bare Act. Your preparation should always start from the Bare Act. And how you have to read the Bare Act? First, read the provision, what is contained in the provision. Then read the explanation about it, which is given in the books, the textbooks, the student edition textbooks. And then identify as to how through different case laws it has been explained. That particular concept has been explained. Now, say for example, if the question comes, now say in case of Delhi Judicial Services, they used to ask big questions. They used to ask big paragraph-wise questions. Now everyone gets threatened by the fact कि यार इतना बड़ा question आ गया, मैं इसको कैसे करूँगा? ये तो पूरा unseen passage type का है. नहीं, it's not an unseen passage. If you will read that question, it's very conceptual in nature. It is very conceptual in nature. And for this, we need to adopt this strategy that first we should have read the section number, then we should have read the textbook, and then explanation about that particular section through leading cases. Now, say for example, in case if the question comes, what is the exact difference between the culpable homicide amounting to murder and not amounting to murder? And a paragraph has been given to you. You have to read that particular paragraph, and you have to identify. I am sure this paragraph must be from some case law. So what is the leading case law with regard to difference between 299 and 300? So you'll say Rex versus Govinda. So it may so happen that what you have read has been asked in the form of a paragraph in the question, and then you will be able to get the correct answer without attracting any negative marks. Without attracting any negative marks, right? So this is how you have to start your preparation. Always focus on developing your base. Always focus on developing your base. If you are reading a subject, even if you take 1 week to read that particular subject, please read that subject very thoroughly. That is how you have to prepare. आप उस सब्जेक्ट को जब थरली पढ़ोगे ना, तभी आपका उस पर बेस बन पाएगा. तब आप ये समझ पाओगे कि अच्छा, इससे घुमा के अगर क्वेश्चन आ रहा है तो उसका आंसर यही हो सकता है. अगर मान लो आपने 299 और 300 को बहुत डिटेल में पढ़ा है, या 34 और 149 के बीच के डिफरेंस को अच्छे से डिटेल में पढ़ा है, इवन इफ द क्वेश्चन इज आस्क्ड in any variation form, you will be able to get the correct answer, even if that particular question might not have been asked in the previous papers. Why it is always suggested that we should read the previous papers? Because 65% of the portion of your current examination is going to be from your previous papers, and the rest of the portion is going to be from your new questions. So आपका 35% ही new question आने वाले हैं, बाकी 65% they are all going to be previous papers. This is the story of almost all the examinations. Even if you attend the UPSC, you will find the same. So 35% of the portion is going to be your new questions, and the 65% of the syllabus is going to be from your previous year question papers. So you have read as to how the questions have been asked. Now when you are reading that particular Bare Act, you are reading the section number, or you are reading the explanation which is given in the textbook, you will be able to identify, okay, this is the point from which the question was asked in that particular year, in that particular state, so I must focus on this particular point very carefully. And you will start identifying as to what is important in that particular subject and what is not important in that particular subject. Am I getting it? Are you getting it? Am I clear to everyone? Is it getting clear to all of you? Yep, very good. Then let's come to mains examination. We know as to how we have to study for the preliminary examination. Okay, very important point, very important point. Sometimes the conceptual questions are also asked from your illustrations. So there are certain sections, there are certain acts, and there are certain sections in those acts, especially the old acts, which have been in force in India since before the commencement of the Constitution. They contain the illustrations. Those illustrations are very important. You will find illustrations in many of the sections of the Indian Penal Code, Indian Contract Act 1872. Sure, Bhargavi, sure. Right? Indian Contract Act 1872, Transfer of Property Act 1882, Negotiable Instrument Act. So you will find that there are certain illustrations given, and sometimes the questions are also asked from those illustrations. Sure, Bhargavi, I'll make sure of that. So sometimes the questions are also asked from the illustrations. So as important the section numbers are, and so are important your illustrations. And if you will analyze the previous year mains papers of many of these states examination, you will also find that sometimes the questions are asked to explain a particular section or a concept based on illustrations. How are you going to illustrate? What examples are you going to quote? So you do not have to hypothetically make any new example. You have to quote the illustrations given in the Bare Act. This is what is the expectation of the examiner. That if the question in the mains examination has been asked as to please explain this particular section or a concept with the help of illustrations and case laws, you will have to quote the illustrations which are given in the Bare Act. So it is not only a preliminary examination where your questions from the Bare Act comes, right? It will also be a mains examination where you will be tested in your illustrations. So illustrations are also very important. So you must read the illustrations which are given in the Bare Act. And to identify which are those important acts where the illustrations are given. So I'm telling you all the acts which have been in force in India since before the commencement of the Constitution contains the illustrations. They contain the illustrations, right? So we cannot skip the illustrations. So we always focus on section number, and many a times I get this complaint as to how to mug up the section number. You start making the notes, you start preparing that particular section, you do it thoroughly as you do for a research, and I'm sure you will be able to mug up the section number. Section number is nothing but a series or a chronological order in which the concepts or the principles of law has been enunciated in the Bare Act. So you have to start your study with the Bare Act, the section number, the illustration, then you go to the textbook, student edition textbook. I'm not asking you to go to any commentary. Student edition textbook. Read what is the explanation given about that particular section. Find out how the section has been explained through leading cases. Then you will be also able to identify the leading cases. And then when you are reading that particular textbook or the Bare Act, once you have analyzed the previous 10 years papers, you will be able to identify the important points in the section of the textbook itself from where the question has already been asked. So you will focus on that particular portion by yourself. You will focus on that particular section by yourself. Try doing this, and I'm sure you will be able to solve the papers which you have not been able to solve completely. You do this, you adopt this strategy, and I'm sure you will be able to complete the entire paper. But give yourself 6 months before you start doing this. First, you analyze the previous papers, then you study, and then start looking into the questions. Or you can also do that. You take up a particular subject, analyze the previous papers, read that particular subject, and then solve the questions only of that particular subject. And I'm sure you will be able to solve those questions. It is especially for those students who are not able to even clear the preliminary examination. So I'm telling you that clearing the preliminary examination is not that tough, right? Now, as I have told you, not yet, Shreya, I have not been able to go through Assam Judicial Services papers. So, as I have told you, preliminary examinations are just the screening out test. So once you have once you have got selected for your mains examination, you have to prepare the subjects with in a subjective manner. That is by writing the essays or by writing the long answers to it. Right. So when it comes to studying, when it comes for the preparation of the mains examination, I always suggest my students that when you are preparing for your preliminary examination, you should prepare yourself for each subject in such a way that you are already going to start writing that you are already going to write the mains examination. So how you can do this? Now, say for example, you have analyzed the previous 10 years papers of the preliminary examination, and you have identified these are the important areas for the Indian Penal Code. When you're reading about, say, for example, section number 34, which contains the concept of common intention, you're reading about common intention, you have read the illustrations are given in the Bare Act, you have read the section number, what the section contains, the illustration, and the explanation. Now start making notes. Start making the notes, right? When you will start making the notes, two things are going to happen. There are going to be two implications for it. One of the implication is going to be you will be able to mug up what you have just read. And two, it is going to prepare a brief for yourself when you will revise that particular subject, either during your preliminary examination or during your mains examination. This is going to be of your help. Then take out the mains question papers. Take out the mains question papers. And if you guys are thinking as to from where to get the mains examination papers, you do not have to go to any textbook. You do not have to go to Amazon or any other website to purchase purchase the books on the previous mains paper. You can go to the websites of the respective high courts. They always upload their mains examination paper. I can tell you this about the Rajasthan High Court and about the Madhya Pradesh High Court. You are always going to find the papers there. They always upload their prelims and mains examination question papers. So you do not have to spend money to purchase any book to just have the look at the previous mains papers. You can always find the mains papers in the websites. Once you have got the mains papers, you start writing the answers. Now, say for example, you have read section number 34. You have been able to make the notes of it. You have read the section, you have read the illustration, you have read the explanation, you have read the reading cases, you have made the notes. Now see as to how the questions on section 34 has been asked in your mains examination and start writing your answers. So you should have two registers for each subject. One is the register of your notes and the other one should be the register of your mains answer writing. And you must write the answers. And this will automatically prepare you for the preliminary examination. Now also look into the questions of the preliminary examinations, and I'm sure you will be able to solve those questions as well. So focus should be on your mains examination. Your preliminary examination will automatically get prepared. This is what is the basic strategy, and which you must adopt for almost all the subjects. Right? I will not focus on general studies as of now because we always deal with the law subjects. But as far as general studies are concerned, now many of the states, like for example, state of Uttar Pradesh, they used to conduct a separate subjective question, subjective examination on the mains on the general studies as well. In those states, for those states especially, right, you have to prepare for your general studies as well. And even if the general studies is concerned, you do not have to prepare it for up to that level like that of UPSC. No, basic one. You are going to be appointed as a judge. You must be having a sound knowledge of law. You are not required to have the sound knowledge of general studies. Yes, some of the states test the candidates on general studies as well, but they test you on the basic knowledge. They always aims for they always aim for for this one. They always aim for. Yes, I have gone through the MP paper, Anjana. I have gone through the MP paper. I have gone through many of the papers. Recently, I have gone through the West Bengal paper. And I must tell you, the civil paper of the West Bengal was very easy. It was all conceptual. It was all conceptual. It was nothing based on the bare act. Important websites. I did not prefer any website for the preparation. What I did was I was preparing through the bare acts and I was preparing through the textbooks. The strategy which I am sharing with you, Tanya, was the only strategy which I adopted for my own preparation. Right. So once you aim for the mains examination, your preliminary examination is already going to get covered. Okay. So either you can, in those cases where you are not able to find the paper. Yes, yes, Dhani, you can obviously prepare through your coaching classes, because coaching classes gives you the guidance. Now, I must tell you, once you go for the coaching, and we also conduct the online coaching for the preparation for the judicial services, and many of our students have got selected for the West Bengal. They are about to write the West Bengal's mains examination as well as the Bihar's mains examination and the Chhattisgarh mains examination. So many of our students are going to write these examinations. You can obviously contact them and try to find out as to how they have prepared. But the point is, the coaching centers are always going to give you only the guidance. What is very important is your own self study, and what I'm sharing you is the tips for your own self study. In those cases where you are not able to find out the previous papers on the websites of the High Courts or the Public Service Commission, you can go for purchasing the books. I was trying to give you an insight as to how you can save your money without spending money on books. You can get the question papers. But in case if those are not available, then we do not have any other choice but to get the books from the market. See, for CRPC, Ratanlal Dhirajlal is very good, but Ratanlal Dhirajlal is more like a commentary. So, you can get that Ratanlal Dhirajlal, you can go through Ratanlal or Dhirajlal, but a normal student edition textbook would also do. It will also do, right? So, it is your normal student edition textbook which you have read which you have read in your law schools or law colleges will also be sufficient. Yeah, sure, Anjana, sure, very much sure. Right now, we have seen as to how we have to prepare for the mains examination. Let's come to our next topic, which is about the legal current affairs. And as I've told you, many of the states used to test us on the legal current affairs as well. This may also be a part of the general studies, that apart from GK, they are also testing you on the legal current affairs. No, I have no idea about that, Tony. I have no idea. So, when we talk about the legal current affairs, we must see that we should have a sound basis or a sound knowledge of our own subject. Now, say for example, if I am talking about euthanasia, if I am reading the newspaper and I am reading the news about euthanasia, that this is a particular judgment which has been delivered by the Supreme Court in the Ramachandra Shanbhag case. And I know that this is a leading case because it has made passive euthanasia legal. If I have to, if I know that this is a very important topic, and in my mains examination, I may be asked to write the, an essay on it, or brief 10 marks answer on it. So what should I do? I have to first have the knowledge as to what is the legal status of right to die, whether right to die is included in right to life under Article 21 or not. Then I have to go through P. Rathinam case, Gyan Kaur case, then I have to come back to Aruna Ramchandra Shanbhag. When I have this sound knowledge with the provisions of the Indian Penal Code and how it is related to the Constitution, what are the leading cases with regard to right to die, whether right to die includes right to life or not, right to life includes right to die or not. Once I have studied about these concepts, then if I read the news about the passive euthanasia, I will be able to analyze that particular news more carefully. Say, for example, the dharnas which are going on, the farmers' protest which is going on. The peaceful protest is always allowed, but what about in case if the mob turns violent? In any kind of protest I'm talking about. What in case if the mob turns violent? What are the sections which will be attracted on the people who are involved in those unlawful assemblies or committing riots when the assembly turns unlawful? What sections will be attracted? What will not be attracted? If in case if you are asked to write a essay on it, if you have studied the concept after analyzing the entire news with your own previous knowledge about the subject, you will be able to write your essay more exhaustively. Right. So that is something which we have to take into consideration, that once we have the sound knowledge of law, when we have the sound knowledge of our own subject, and when if any current affairs comes from that particular subject, we should be able to relate it. Okay, this is passive euthanasia. I have read this thing, I've read the P Ratinan case and the Gyan Kaur case about the legal status of whether right to life includes right to die, and I am able to relate it to the concept of passive euthanasia. I will be able to write a good answer on it. If I talk about right to privacy, I have read about MP Sharma versus Satish Chandra case, and I've read about Khadak Singh versus state of Uttar Pradesh. I have read this that this is a particular status of right to privacy. Now this is how the Supreme Court has changed the course of law. Now this prepares my answer, either a 10 marks answer or an essay on it. I will be able to write it more thoroughly, right? So this is how we have to prepare for the legal current affairs. So this is what we have to take into consideration. We should be able to relate what is the current happening with what we have already with what we already know in our subject. This will prepare us for the examination with regard to legal current affairs. Now, say for example, if the as far as the preliminary examination is concerned, in case if the question comes, which case law has enunciated right to privacy as a part of fundamental right, we will be able to take in K. Puttaswamy. And what in case if in mains examination you are asked to write an essay on it, you will be able to write, okay, this was the status of right to privacy before under Article 21. Now this is the status of right to privacy after Puttaswamy. And what are the implications of Puttaswamy? Right? See, main subject for preliminary and mains examination. Now, if you ask me main subject, I will say all the subjects which have been prescribed in the syllabus are main subjects. You should not focus only on one subject and say, okay, I have prepared the major portion of the exam. You cannot, you should not say that I have prepared CRPC or CPC and then I have prepared the major portion of the examination. It is not going to happen. So if you will see the paper, you will find that one or the other question from each and every subject has been asked. One or the other question from each and every subject has been asked. And our focus, our objective should be, whether we are writing the preliminary examination or whether we are writing the mains examination, our objective should be to complete the entire paper. We should not leave any question. This is the first thing which we should keep in mind before writing the paper. We should complete the entire paper. We should not leave any question. क्योंकि होगा क्या कि in case if you are not able to score good marks in one question, you will be able to cover up in the other question. So each subject is important, even if it's a minor subject, even if it is a local law subject. Even if it is a local law subject, you will be able to cover your marks. So each subject is important depending upon how many questions are asked. As far as preliminary examination are concerned, in case where there is no negative marking, I must suggest you all, in case there is no negative marking, like say for example in the state of Chhattisgarh or in the state of Madhya Pradesh, when there is no negative marking, you must attempt all the questions. You must not leave any question, right? But in case where there are negative markings, say for example in the case of Delhi Judicial Services, UP Judicial Services, where there is negative marking, you should be selective, very selective. In case if you are not at all sure about that particular question, you should not attempt it. In case if you have the slightest of probability, okay, on the basis of probability, you can guess, okay, this can be the probable correct answer. You should take on that particular, option of that particular the question. But in case if you're not at all sure and if there is a negative marking in the question paper, you must not attend. You must not attend that particular question. There is no, there is no wiseness in attracting the negative marks. Where we even have the slightest of hint, okay, this can be the probable answer, we can always stick on that particular option. So this was all what I wanted to cover in today's session. Now I open the session for the audience. In case if you have any doubt, you can put it. And before that, I must tell you that from tomorrow, the Rostrum Legal is going to start a new batch for the foundation batch for the preparation of judicial service examination. And I used to, guide the students. I am the mentor there, so I will be teaching that particular subject. In case if you want, we are starting with a demo class tomorrow. If you want, you can join. The link for the demo class will be sent to you through the SMS by the Rostrum Legal. Slides, okay. The slides will be uploaded in the website of the Rostrum Legal, Meghna. As I have told you, Vanita, as I've told you, okay, Anshu, I'll come back to your doubt. Let me first answer Vanita's doubt. So, as I've told you, Vanita, most of the websites of the High Courts or the Public Service Commission already upload their prelims and mains examination questions, right? So, you do not have to spend spend a good amount of money for purchasing those books. What you can do is you can go to the websites. In case if it is not available, then you can go for the books. As far as the mains examination questions are concerned, for preliminary examination, I always suggest singles. There is one good thick book of singles, which is quite costly, around 1000 or 1500, but it contains the previous 10 years question papers of almost all the states of India, which is very important. Acha, the other important point is please do not go for your private question banks, which only contains the questions in chronological orders of the section number of the Bear Act. They are not going to be helpful to you. In case if you want to make sure that whether you have been able to mug up the Bear Act, then you can go and attempt those questions. But as far as clearing the preliminary examination is concerned, you should always go for the previous papers. And I always suggest singles as the best book to be purchased for the previous year question papers. Yes, case laws are necessary, Priya, for those answers where the question itself contains the instruction that you have to explain this particular concept with the help of leading cases or recent cases. There, the case law becomes very important. And in case of preliminary examination, those case laws must be in the form of the question itself. So yes, obviously we have to prepare for the case laws. Singles, judicial service examination papers. Yes. You should always go for previous papers. Kanika. See, interview is more about testing your personality. Now, say for example, who is this one on the interview? Let me see who has asked the question on the interview. Okay, Avinash. Now, say for example, Avinash, if I ask you, okay, Avinash, tell me about the place from where you belong to. So you will be able to, you are now going to recollect as to what is the important, what are the important areas of your state, what is the speciality of your state, what is the special food, what are the special tourist places. This is you are going to, say. Now you would be expecting some questions on law, but as I have told you that in interview they are going to test your personality. Yes, they're going to test your personality. In testing your personality, they can pose you any question, whether it is of law, whether it is not from law. I have seen many of the candidates who have appeared for the interview. They were not asked a single question on law. Say, for example, if you are a female candidate, if you have come, in case, especially if you are a married candidate, they may also pose you questions like, okay, tell me something about your POXO, because you're a mother to two children. Do you know something about POXO? Because as a mother, you must be knowing if you are protected towards your child, you must be knowing about POXO, Prevention of Children from Sexual Offences Act. Right? So even these kinds of questions have been asked to the candidates. Depending upon what is your background, they may pose you any kind of question. I'll write it down. I will write it down. Judgment writing. Now, judgment writing for preparing for the judgment writing. Yes, Vanita, I'll come back to it. Samruddhi, answering to your question, if you want to prepare for judgment writing, you must be thorough with your concept, because what you are going to write in your judgment is nothing but your concept. If you would have looked, if you would have gone through the this time's mains paper of the Chhattisgarh, the questions were very direct. If I discuss the civil question, civil judgment writing question, the question was that A executed a sale agreement with B in favor of B for selling the plot of land. We all know that sale agreement is not a sale deed, because it is not transferring any rights or interest over the property to the B. It is merely an agreement that on these terms and conditions sale is going to take place. That on these terms and conditions sale is going to take place. When B instituted the suit for specific performance against A was taking the defense that I did not execute this sale agreement, but I executed it as a security agreement. If you identify this, then this is a kind of a transaction where if I am taking a loan from some other person and I do not want to go into the cost of registration of the mortgage deed, what I will be simply doing is I will be executing a sale agreement as a security. So what we need to identify here is that what basically they want to test us on, how we decide whether it is a sale agreement or whether the sale agreement was executed as a security for the repayment of loan, right? So we need to understand that this is something, a separate oral agreement, which it is about a separate oral agreement which the defendant is taking a defense of. The defendant is trying to say that yes, it's a sale agreement by the terms and conditions which have been included there, but I entered into a transaction of loan with Mr. A. I obtained a loan of rupees 3 lakhs, out of which I have already repaid rupees 2,50,000. But I do not have any but I do not have any documentary proof as to how I have repaid the 2,50,000. But I have repaid. So there was a separate loan transaction, and as a security for this loan transaction, I executed the sale agreement because we did not want to go for the registration of the mortgage deed, right? So you have to decide whether whether it was really a sale agreement or whether it was executed as a security for the repayment of loan. How are you going to decide? Now you need to first identify where the oral evidence about the separate oral agreements can be given. This brings us to section number 91 and 92 of the Evidence Act. Section number 91 of the Evidence Act discusses that yes, in case if the execution of the document has been proved, right? So there cannot be, and no oral evidence will be allowed apart from the terms and conditions of the document. But section 92 says that to bring any contradiction, variation, addition, or subtraction, the oral evidence can be given. When the oral evidence can be given, in case if that contradiction, variation, addition, or subtraction falls within any of the 6 provisos which is given in section number 92. This is how we have to identify the question, and that is how we have to write the answer. That is how we have to prepare the judgment. What this brings us to a conclusion of? This brings us to a conclusion that if we are thorough with the procedures and the evidence, the principles of evidence and the substantive law, which ultimately takes us to back to the concept that when we are preparing for the preliminary examination, we have to be thorough with the subjects. So yes, in case if we are thorough with the subject, we will be able to identify what is the question of law on which the problem is based and what I have to write, which is going to fetch me good marks. 1 year, 1 year at least. See, the questions based on amendment will specifically contain whether the question is based on amendment or not. Now, say for example, there have been many amendments in the specific relief act in the year 2018. If the question is based on the amendment, the question is specifically going to contain the instruction, please answer this question on the basis of the amendment act. So you do not have to, because it is ultimately going to create a confusing situation for the candidate sitting there. It depends upon state to state. वैसे the maximum age limit for appearing for these examinations is 35 years, and for women it is 45 years, I guess. This is this is what is the position in the state of Chhattisgarh. I do not have exact idea about the age limit for the other states. As far as higher judicial services examination are concerned, the eligibility requirement is that you must be of the 35 years of age and must have 7 years of practice experience. If you are a Hindi speaking candidate, you must attempt all the Hindi speaking states. You should not stick to your own state because you may not be able to clear in first attempt. You should not miss out the opportunity because you were not able to, you did not fill out the form for the other states. So you must, it is just like spreading a net to catch the fish. I am preparing for all the states. कोई ना कोई तो निकलेगा. Yes, mock tests are very necessary. Yes, provisos are as important as section because they are the part of section. What is proviso ultimately, Avinash? Provisos are the exceptions to the general law which is contained in the section. Provisos are the exception to the general laws which is contained in the section. So yes, it's a part of section. You have to read it, and sometimes you will find that the illustrations are also based on the provisos. Yes, exceptions. Yes. Any other doubt? There is one Pariksha Manthan, I guess. There is one Pariksha Manthan which contains, a good amount of latest cases and landmark cases. Also, there is one of Universal. Also, there is one of Universal. So you can go for these two books for the questions based on case laws. Okay. Any other questions? Any other doubts you would like to clear? See, he did not clear the judicial service examination. That is why he is teaching you. In case he would have got selected, he would not have been teaching you. He has the experience. He has a good amount of experience. That is why he is teaching you. See, it depends upon the number of marks which have been allotted to that particular question. In case if it's a 10-mark question, you must be, confining yourself to the word limit in case the word limits are given. In case if the word limit is not given, in case if the word limit is not given, you must be, not writing the answer of more than 1.5 page. In case if it's a 10-mark question, and in case if it's an 8-mark question, then you must confine yourself to 1 page. So that is how you have to identify. For this, you will have to see to the already selected candidates as to how they have written the answers, how did they made the judgment about the number of about the word limit and all. So this is what is what has to be taken into consideration before we start writing the answers. There is no such current affairs book specifically for West Bengal examination. The general current affairs book is also sufficient in case if they do not specifically ask a question about the West Bengal only. Half a page answer. See, in case if you can write the Hindi, see what happens is ultimately what you have to understand here is, guys, that they are going to select you for the post of a judge. You must be thorough with the knowledge which is being used there locally. Now, say for example, if you come to Chhattisgarh is a Hindi-speaking state. The examination conducting authority would be expecting you that you should be able to dictate the judgments in Hindi, and that is why they contain the questions on translation from English to Hindi and Hindi to English. Now, when I say English to Hindi, it does not mean general Hindi; it means legal Hindi. Now, you will say, from where to learn this legal Hindi? So, if you have been preparing for judicial service examination, you must be knowing that there are two kinds of bare acts which comes in the market. One is the bare act which is purely in English, and the other one is the bare act which is, in both the language, that is Hindi and English. So, in case if you want to learn the legal Hindi, you can start translating the bare act. You can look into the Hindi sections and you start writing it. This way, you will be able to catch up the words which are used in legal Hindi. It depends upon your own personal capacity, Nikhil, as to how much you can devote your time. But अगर आप आधे घंटे भी बैठो, in case even if you devote half an hour, you must devote it such so much that you are able to understand that particular concept very thoroughly. You can contact the previous selected candidates in case if they are willing to share the notes with you or not. Ultimately, they have got selected, so I don't think so they might be having any problem in sharing their notes. See, this depends. That is why I've told you. It's just like your current affairs. It keeps on increasing day by day. So first of all, you should focus on the leading cases and then on those cases which are not leading cases but has been asked in the previous examinations. And for this, I have told you the strategy that you can go through all the previous year question papers of all the states, try to find out the common questions based on common cases and how the answers have been given. That is how you can prepare for the case laws. Okay, guys. So we are going to start with the new batch tomorrow, and we are going to have the the demo class from Monday. In case if you want to join, a link for joining the class will be sent to you by the Rostrum Legal through the SMS. Yes, 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 yes. That you have to do. That you have to do. No, the pattern is almost same. Some states used to ask questions which are problem based, and some states used to ask direct questions, and some states used to ask analyzing questions. So in case if you're preparing, you prepare from all the aspects. Whichever state come, you are prepared for it. Meghna. Okay, wishing you all the very best for your endeavors. Priya, a link will be sent to you via SMS by the Rostrum Legal. You can join the class through the link. You're welcome, Tanya. Welcome. Okay, I wish you all the very best, all of you who have attended this session. First of all, I thank you all for attending the session, and then I wish all the very best to all of you for your successful endeavors in your examination. Bhargavi, we conduct the medium of instruction in Rostrum Legal is English, so you do not have to worry about Hindi. No, there are first few demo classes, then there is a paid class. Yes, classes are fully in English. Sure, link will be sent to you via SMS by the Rostrum Legal or in your mail or in your email. You will get the link. And from tomorrow, we are going to start with the demo sessions. Sure. Okay. See you all, guys. Thank you all.